is one of those fields that is serious, and estate planning is quite a serious subsection of our field. When people come in to see us, they start by letting us know about their finances, taxable situations, their health. And family dynamics are a big part of how we deal with an estate plan and what we're going to recommend for somebody to achieve an estate plan. With that kind of heavy seriousness that goes along with what we do, a lot of times I try to remove some of that heft. And we came up with a great way to do that, especially in terms of the family dynamics part. Because when we did this presentation last year, I was here with Kathy Ryan, we got a lot of questions afterwards about blended families, complex family structures, people that have mental illness, people that have substance abuse issues, or even estranged family members. How do you deal with that? So when Rachel and I started talking about it, we thought, well, actually, these type of complex family situations are very common, and they're so common that Disney has fairy tales about these things. So why don't we talk about it that way and make it a little bit lighter, because everyone's situation is unique, but it's not uncommon, and we hear these stories all the time. So we're going to use some of the Disney stories to achieve some of the stories that we hear with family dynamics and how we address those with legal tools. So, first one we're going to talk about is Cinderella. That's the first one that came to mind for me. If anyone has ever had a second marriage or a blended family or anything where we're raising two sets of kids, maybe that some are yours, some are not yours, we're thinking about Cinderella here, and I was lucky enough to have my niece who's a graphic designer help me with this. I'd love to say that we drew these things, but we were just trying to avoid copyright laws. So what we did here is we talk about Cinderella. So her father died, and she was raised by her evil stepmother and her two stepsisters. That may not be what her father envisioned for her if something were to happen to him. How do we protect our kids if there's a second marriage situation? So that's what we started thinking about here. How do we do it? The answer here really is trust to handle finances. And if someone's underage, what we use for a tool is we use a will in order to be sure that we're nominating guardians. And also in the case of incapacity, we want to do the same thing, where we're nominating guardians for our minor children.
Trust officer with Washington Trust Wealth Management. So I deal a lot with trusts, and I deal a lot with situations. Is that better, guys?
Yes.
All right, thank you. I deal a lot with situations where a little bit of pre-planning would go a long way. One of the considerations is asset titling. Do you have real estate? How is that real estate titled? Is it in your name? Is there a life estate? I'll tell you, in Rhode Island, what I see a lot is beach lots. Maybe you and your sister inherited a beach lot, and you each have a 1/2 interest in the beach lot. That sounds great until we start getting into next generations. And that can get really complicated really quickly, especially when your assets are going into a trust. So now the trust owns half of your beach lot, and your sister still owns your beach lot. Those are the kinds of things that somebody like Amy can help you look at prospectively, so that you can figure out a strategy to make sure that it's simple for people to kind of unwind and figure out a plan also with your family about what you like. Because I think that's important. I think a lot of what we do is trying to put the power in your hands so that we can effectuate what you want, and what you want for your family and what you want for yourself. One thing I see a lot is issues around beneficiary designations. And I'm going to harp on this quite a bit because the tough conversation and the tough discovery is when somebody says, oh, my husband passed, oh, I'm so sorry, I would like to take his IRA now. oh goodness, his ex-wife is still the beneficiary on the IRA. And you think, oh, that doesn't happen, but it does. And one of the things about beneficiary designations is you can use that to both protect your current spouse, you can protect your children from a prior marriage, and you can also, if you have someone in your family, a child, a grandchild with special needs, with somebody like Amy, you can put together a special needs trust and utilize some real tax benefits to leaving IRAs to a trust for a person with special needs. And finally, when you have bonus children, you might be the beneficiary of a trust, for instance, that leaves assets to you for your lifetime and then to, there's this fancy legal term, to your issue. Well, depending upon how that's written, that may or may not include your bonus children. And if you're in a family where folks get along and you want to be fair and inclusive, again, planning with an attorney ahead of time will allow you to do that.
But what we want to do is be sure that we're planning for the people that we want to plan for and how we want to plan for them, whether it be through a trust or we can use beneficiary designations on a lot of different types of accounts, particularly retirement accounts. So I think that's a great point. We can move on to Finding Nemo. So Finding Nemo is one of the newer Disney stories, and what we're talking about here is protection and guardianship mostly. So guardianship I touched on previously, where if you have children and you want to be sure that you know who is raising your children, so we're talking about day-to-day placement, custody, as well as financial matters. What we use is we use trust. We also use powers of attorney for incapacity matters. So what we've done here is we talk a lot about Marlin and the concern for Nemo's safety. Nemo it's a coming-of-age story, really, where Marlin is trying to release some of the control he has over his son Nemo, and Nemo is finding his way out in the big world. Creating a guardian and making sure that we have protections for Nemo in place, just in case something were to happen to Dad, is really important.
Some of those considerations, again, for a sole caregiver are both who is going to be the best person to manage the day-to-day raising of a child or managing the affairs of a person with special needs on a day-to-day basis. And also, it doesn't have to be the same person as whoever is managing the finances, because sometimes those skill sets are not in the same person. And one option is, for many people, a trust. So you can pull in a professional trustee to take some of the management of the money, especially over the long term. When you think about raising a child, it's not just getting them to 18. There may be additional education needs, or with somebody with special needs, that can be kind of a lifetime of need to plan for somebody's affairs. And that's where a professional trustee can assist. The professional trustee is going to be working as a partner with the family members who are raising the child. And many people will have a family member as a co-trustee as well, and that provides invaluable input as things get administered over the years. And Nemo had a lucky hint. When you have a family member with special needs, you need to be very careful about planning around available government benefits. And again, an attorney like Amy can help you create a special needs trust that will protect those benefits over the long term. And also, some of the special needs trusts may be for someone who might have the potential to be independent and self-supporting down the road. And someone like Amy can include decision points along that person's lifespan to help make a determination as to whether or not they may be able to manage their affairs and their finances. Finally, a letter of intent or instruction is an invaluable tool for helping somebody who might be the next caregiver in line look out for your child or even, again, an adult with special needs. As a parent or as a caregiver, there are so many things that you know about the person that you're taking care of. So, for instance, what's their favorite coffee shop? How do you get them to brush their teeth or eat their broccoli? What is their medical history? All of these things that you know and you do and you take for granted without even thinking about it, if somebody else has to take over that care, they're not going to have all that information at hand unless you provide it to them. And the letter of intent, it's not a legal document, but it can be really helpful when people need to step in if you can't care for your loved one.
A letter of instruction is so important that I advise most of my folks that come in and do their estate planning to have a letter of instruction, because even without a special needs individual involved in the plan, a lot of times some people just want to express why they're making the choices they're making. Why am I having a trust? Why am I leaving this particular item to this person? Why am I leaving this particular account to this person? Why did I choose a professional trustee rather than my oldest daughter, which is usually the one that we see? And there are really great reasons to do that. Usually when we're talking about professional trustees, what we want to do is eliminate any type of dissension or friction between siblings or family members. We want to be sure that we're using professional trustees who know how to do these type of matters and manage the finances. So the letter of instruction is invaluable, and special needs trusts are something that we can certainly talk about, but I find that even when we're dealing with our elders, we're caregivers for our parents, we need to be sure that we have, even if we're doing our own plan, if we're taking care of our parents, our step-parents, whoever they may be, a letter of instruction is really important so that you leave behind instructions in case something happens to you and someone else needs to step into that role. We'll go on to our final example, and that's going to be the Lion King. Oh, we have two more, sorry. So the Lion King, Legacy and Succession. So we talk a little bit about the story where Mufasa has lost his life. Simba is not prepared to lead because he's just a baby. We need to be sure we have a plan in place. So what we do is we create clear succession plans, particularly on the business side of estate planning. We do a lot of business work in our office as well. Who's going to have the mom and pop coffee shop? Who's going to lead that if something happens to mom and pop? What's going to happen to that business? And as Rachel mentioned, there's discrepancies. There are some people who are great at running day-to-day operations, other people who are great at managing finances and marketing. We want to be sure that we have those different roles set up. So again, we use helpful tools here. We have trust, powers of attorney, and our buy-sell agreement. That is a agreement, not just agreement. It's a special kind of agreement. But we use those for businesses. Not so much applicable to our audience tonight, so we don't have to worry about that. But in terms of succession plans, we want to know who's going to be the caretakers, particularly with our elder folks.
And as Amy said, they don't have to be the same person. Sometimes you have family members with legal background or medical background or financial background. And as Amy also mentioned, communicating, maybe even ahead of time with the family members, will help them understand why you select particular individuals for particular roles. And sometimes choosing that one person for a particular role can cause some hurt feelings, as you mentioned. And so having your wishes and your reasons expressed in documents, having those communications ahead of time can just help keep things harmonized when everybody's under stress, when there's an emergency or passing. And finally, build in contingencies, because the person that you think might be ideal for a particular role may not be able to fulfill that role. They may have some caregiver responsibilities of their own for a spouse or a child. They may pass, they may have health issues. And that's where thinking ahead of time and putting in some backup plan basically will be helpful.
We got one more. Beauty and the Beast. So, the Beast needed care. Elle was able to step in. We talk about illness and incapacity, and we just don't know when that's going to happen. In terms of my planning that I do for my clients, I almost always include a springing special needs or supplemental needs trust. We don't know when that accident's going to happen. If it's going to happen, we always hope it's never going to happen. But if someone has an accident and becomes disabled later in life, we want to be sure that they're protected and any benefits they're receiving are also protected. Again, we use special needs trust for that. We don't want an inheritance to come in and throw somebody off their benefits. It's really important that we have that ability to plan for that. We also want to be sure we're planning for healthcare decisions. Healthcare is one of the most complicated conversations that I have with people, because a healthcare power of attorney really has three main components. One, who's going to step in and make decisions for me if I'm not able to make decisions for myself? So that's the who question. The second question, though, is what are they going to say? And that's when we start talking about a living will or advanced care directives or even a non-binding letter of instruction. What would you want your healthcare proxy to say on your behalf if something happens? It's really important that we have those conversations. We also have conversations about organ donation. We have conversations about religious preferences. We have conversations about all of a wide-ranging set of ideas that are all attributable to that transition from life to our next life. The final one we always talk about is HIPAA, and I think that probably everyone here knows more about HIPAA than I do, but HIPAA really addresses healthcare documents, who's able to get access to them, because we want people to have access, especially our healthcare proxies, so they can make decisions. Who else is going to have access to them? Do we want our attorney to have access to them? What if there's a malpractice action? What if there's a wrongful death action? We may want to bring more people into the fold to be sure that we have that type of backup. So healthcare power of attorney sounds like a very simple document, and it can be, but it addresses the who, what do you want them to say, and then we also have to talk about documentation.
And again, considerations include financial continuity. Most of the businesses with whom you do business, from the cell phone company to your doctor to your bank, all have privacy regulations that govern to whom they can speak. Having somebody of your choosing able to step in and assist you and make decisions when you can't enables your business to get done, and it enables to get it done in a timely fashion. Make sure that bills get paid on time. Also, there's somebody to call in case one of your providers, and I do see this in the banking world and in the trust world, one of my clients is forgetting that she already took her documents over to her CPA last week, and she's calling me to ask to send a copy of something that she needs again. I start to get concerned. I can't just talk to anybody because she's my client. If there's a power of attorney in place, then I can talk to somebody whom she selected and she trusts. And also in the financial industry, we are, in some sense, a guardian of people's finances, because sometimes we see requests that don't make sense. We get to know our clients, and somebody starts asking for money for a trip that they want to take, and they need to talk to us about their trust, or they're coming in and they're asking for funds for a Disney condo purchase, and they don't really have a clear explanation for that, then we can start our investigations. But it's great if we can talk to somebody whom they've selected, who cares about them and knows their situation. And then it's the same kind of thing that Amy described with medical care. Providers want to know what your preferences are. And giving some guidance, particularly around end-of-life issues for your family, can relieve some of the burden and some of the guilt potentially that would come with some hard decisions around end-of-life choices. So if you can upfront provide that guidance, that's really going to save your family some heartache potentially. And then finally, if there's not a substitute decision maker, guardianship is an option, but guardianship can take time, and it's also not necessarily the same decision that you would make, because the petition for guardianship goes to a probate court, so the court decides rather than you. So if you talk with somebody like Amy ahead of time and you get these ducks in a row, there's an opportunity for you to create the plan that you want.
And guardianship is public. So when you hear court, I just want you to hear public, which means medical issues, public. Financial issues, public. Now what I do when I do a guardianship is I go in and I ask those records to be sealed, but that doesn't automatically happen. So it's one of those things you want to avoid, and you avoid it with powers of attorney. They're very simple documents, they're relatively inexpensive, very easy. So then what we did is on the last slide, we just listed a couple of other fairy tales just to give you an idea that there are other Disney issues that are out there that address complicated family dynamics. Any closing thoughts?
We will have some questions later and some additional thoughts, and I'd love to hear yours.